All right, I believe we are live. As always, Alphonse is fashionably late. He said he had to get dolled up for everybody and all fancy. Can you believe that? He says, I keep wearing nice shirts and things of that nature. Uh, but while we are waiting on Alphonse, we'll tell everybody hello. And I'm going to deviate a little bit from the law, just a little, on a topic that I have coming up here very soon. I'm going to speak. I think it's August 22nd on the Crow Show again. There he is. Well, look at him. He got all fancied up for us.
We'll lie.
Hey, Alphonse.
What's happening?
I guess you don't need any introduction. Anyway, I'm going to continue on and then we'll get started here. So I've got an upcoming show on the Crow Show where I will be discussing ESG scores, the sustainable development goals, and things of that nature, and why these are the most important issues in front of us, and not all the crap everybody's worried about, because it all the glove fits in one box. And so, for instance, Alphonse fighting property taxes. Most people are trying to get free of the property. So, Communism by Karl Marx in his book, in one sentence, is the removal of all private property. Okay, so that's just the fact. It doesn't matter whether you go to North Korea, China, wherever, the state owns all the land. And that's where we're headed. Okay, but it's a two-pronged approach to this day. It's called neo-communism, I guess, which would mean new communism. So we're going to speak about these ideas today as we move forward, because what we are finding in the courts, especially me, I'm facing ideological zealots. Okay? And so when you're facing ideological zealots, they will do what is called mental gymnastics let me fix this, guys. My mic's way over here. How about that, guys? Is that better? Whoa. Sorry about that, guys. Can y'all hear me now? Anyway, so what they'll do is mental gymnastics instead of findings of facts and conclusions of law. They're ideological zealots, so they're going to do everything they can to contort the cases towards their ideological belief system. And it's unfortunate. This is a fact. This is why the trial courts are so wishy-washy, and a lot of trial courts have a remand rate that is just ridiculous, right? So with that, always know what we're going to talk about today is how to continue putting pressure on the judge, the clerk, and the court. And the reason for that is if you already know, for instance, in the Middle District where I'm suing the judge, I'm going to end up suing the clerk for failure to do his duties, and suing the United States Marshals and Walden Security. Okay, anybody within that court is not going to rule in my benefit, right? So where do I want to go? I need to get to the appellate court. I need to get to some adults. So we'll talk about some avenues there today. Alphonse, do you have any upcoming episodes, or say hello?
You were talking about the Marxism stuff. And one of my favorite quotes was when they did a reassessment here in like 2019 of all properties, and on the Brandon, on the county website, on the front page it said, "So we can all pay our fair share." Okay,
that's right.
Where have you heard that from? Where does that come from? Isn't that Communist Manifesto?
That is exactly it. And while we're
Constitution, can't find it anywhere. Constitution.
And while we're doing this, let's go ahead and do this. Let me put up a little quote here. So you have to know the two-pronged approach too, guys, because we'll talk about it as we keep moving forward. Fascism should more appropriately be called corporatism because it is a merger of state and corporate power. So one of the issues that we have coming forward with us, we went through COVID-19. That was complete fascism. That's where the CMSs, the OSHAs, the unelected bureaucratic fourth state, which is the administrative state created by Woodrow Wilson, went out and dictated to the corporation something they must do.
Hey, let's touch on it real quick, because I actually had this in a motion I did. Whether it's a municipality or an agency, listen, here's what statutes are. Whether it's an agency or a municipality, they have to be expressly granted rights from the legislature through strictly constructed statutes. That's because an agency and a municipality are what? Creatures of the state, okay? And by definition, by creature of the state is a creature of statute. That's what statutes are. That's how the legislature dictates to creatures of the state under the statutes how they must act, okay? Like he's talking about corporatism. What they've done to us is they've looped you into these administrative courts, okay? So you're in a court. You think you're in a judicial court of law. No, no, no. You're in an administrative corporate court, okay? You're being treated like an agency or a corporation or entity organized under the state statutes. And that's why you've heard judges say, don't bring that Constitution in this court. That's where that comes from, okay? Because those courts only run by what, Brandon? Statute.
That's right.
Everything runs by statute in those administrative courts. So that's
I'm gonna hang that up there for the tribe and answer it truthfully. No. But here's the problem with it, right? Because the entire goal of the administrative state, which was admitted by Woodrow Wilson, was to remove the Constitution. That's the goal, right? So we always should have, and let me go back and restate that. Yes, because what we should have between you and I and between corporations, which are artificial persons and artificial persons, is the common law. That's it. That's it. Common law should be dictating our interactions with each other, and constitutional law should be dictating government's interaction with us. So the entire goal and purpose of the modern administrative state was to have what we have today, what is called rule by experts. Okay, that means somebody walks up to the damn podium with a white jacket on and says, I've been to Harvard for 20 years. I get to dictate to everybody else what they think. And it's always the same thing, too, because it flies in the face of empirical evidence. But we're living in the realm of what's called consensus, right? Scientific consensus or medical consensus and things of that nature, where we no longer have to prove anything. Facts and reality don't matter. Neither does logic and reason. So with that said, we'll talk about this little deal right here. This two-pronged approach that you must understand. We are living in a time where most of the people that you're going to come up against are deeply entrenched in what's called a religion. Okay, they don't know that. They might claim they're atheists or whatever, but they're out here doing social justice stuff and things of that nature. But their religion is neo-Marxism, neo-communism, whatever. And you have to understand that. So when you go to this court and you get a little pushback, you have to learn the rules a little bit better. For instance, and we can go off into the law now because I'm not going to delve off too far, but we'll talk about the furries later and things of that nature if you want to, Alphonse. But for instance, we'll talk about the current case with the judge. Okay, so we did a motion for clarification and a motion to allow us to e-file, and I'll explain to everybody why. We were hand delivering motions, and the clerk literally the longest time he sat on one was 11 days. That's a violation of his job, his duties, his functions, and his responsibilities. The only way you can sue a clerk, by the way, is him not file. Hey, that's it. That's the only way you can sue a clerk. Okay, so we did the motion for clarification to identify which court were we operating under. So let me explain to everybody. We filed a lawsuit in the Middle District against Shelley D. Dick, United States Marshals, Walden Security. All right, the entire courthouse had to recuse himself. So she shifted it to a different district. So let me explain, catch everybody up. For the last 2 months, we have been operating by 2 sets of local rules. Just judge decides it's his personal preference. Yeah, you muted yourself. You're muted.
Didn't you have 2 clerks at one time acting at the same time?
They're still doing it.
Was in charge here?
Yeah. They're still doing it. So what we did was we compiled a motion for clarification to identify everything. Well, Maurice skips over all the problems and says this will solve all the problems that we're going to allow you to e-file. No, it doesn't. It doesn't solve anything, Maurice. You still haven't stipulated who. Okay. So the one thing he did, it caused himself to lie. He said that the Western District clerk is now in control of the case. Well, here's our issue. Because by local rule 7F and 7D out of the Middle District and the Western District, no one gets to file surreplies to a 12B6 motion. Okay.
And explain real quick what surreplies are for people. It's it's a double answer, right? It's a double answer.
Well, yeah, it's a double answer. So you always have to check your local rules. Most local rules do not allow what's called a surresponse and a surreply. So let me tell you what that is. Okay. So I file a motion. All right. I file a motion. The opponent gets to file a reply brief. I do not, unless the local rules allow it, I do not get to do a supplemental briefing or a reply to a reply, because the pleadings are now closed. The briefings are now closed with the motion and the reply brief. Okay. In order to supplement that, you got a motion to leave the court. Okay, so let me catch everybody up here. So we have a clerk enter 3 orders, by the way. Mitch McConnell enters 3 orders into the record, allowing the defense for the marshals, defense for the judge, and the defense for Walden Security to have surreplies to their 12B6 motion. Not only that, gives it a motion hearing, denies oral argumentation, and lowers the time period for us to reply. Now, to make even matters worse, it was originally ordered on, I think, May 23rd. We never were mailed the notification. Never mailed the notification. Nine different mailings, and the clerk of the court claims that the United States Post Office must have messed up for 9.
Yeah, that was written.
So to just show you the type of so why is this episode named Monkey Business? Because it is monkey business, folks. We're armed with truth. We're armed with values. We're armed with integrity. And we are facing people trying to cover up crimes. Okay. So the only thing that you can possibly face is more monkey business. Okay. And so with that, you have to be diligent. So now we can e-file, because the clerk just refuses to do their job. Not only that, when we walk into the court, we have armed guards traveling us, detailing us around like we're domestic terrorists, because we believe in the Constitution. You know that. But nonetheless, so we refiled the Rule 52 motion. And this is for the findings of fact and conclusions of law, for the failure for the judge to give us the declaratory and injunctive relief and apply the strict scrutiny standard to Judge Dick's administrative orders. Hey, listen, we've got this in the bag. We've got so many judicial errors. The failure of the judge when denying the declaratory relief and injunctive relief for not giving us by law, he's required to give you the findings of fact and conclusions of law. Okay. No, we've got a motion for it. So now it's sitting at his desk, and another motion for clarification has gone in. Listen, folks, you can motion the court for everything.
Yep.
If you've got monkey business going on, make them answer. Don't let them get away. Hey, listen, right now, at this time, I've got a judge telling me that both local rules are applying to us. And get this, Alphonse, this is from Maurice, that his personal policy is to always give people surreplies to motions to dismiss. Whoa, Maurice.
On his own court system?
Yeah, well, that's what I said. It's not in your local rules, pal.
On his own court system, on private court system he's running.
Yeah, he's running his own court system. So now, but what I'm trying to explain to you people out there, that this isn't a fast process, especially in the federal courts. Not in any of the courts. When you bring, nobody really wants to rule. Listen, nobody wants to rule at the trial court level, knowing for a fact that Gary and I have bogged them down in the rules of interpretation, canons of construction, and the fact that the administrative orders that she was given only applied to her employees. That was it, under her direct control. It did not apply to you and I. Then we've got the public-private partnership, right? There's a reason that government employees are no longer at the door and that Walden Security is now on the detail. They think that's a degree of separation, but it isn't, because you need to know the public function test, the nexus test, and then finally the symbiotic relationship test. So anybody getting paid federal funds are liable for discriminatory suits. And that's going to be Title VI. Hold on, let me get this right. Yes, Title VI, 1964, the Civil Rights Act. But this is what we're facing in my case. And matter of fact, two of my cases. Mine and Gary's and one on my own. So what did we do? We got all these motions to dismiss just sitting there. None of the attorneys have filed a hearing. Why? They don't want us in court. Why? Because
they didn't request a hearing for any motion, right? They don't want to.
No, they don't want a hearing. They don't want.
Well, let's clarify this, because I was trying to explain this to somebody in our group. Listen, just because an attorney files a motion to dismiss, it doesn't indefinitely halt the case. Okay, he's got to do something with that motion. Now they're saying, "Oh, well, the judge got to answer it." No. It's up to that attorney to set that motion for a hearing. Okay, you could set a motion for a hearing. You could request a hearing. Just because somebody files a motion, the case does not suspend indefinitely until somebody does something. Doesn't work like that. Okay, the clock still rolls. If you don't have a goddamn response in 60 days for a government entity, they weren't. You got no responsive pleadings to your filing. Okay.
And by the way, don't tell them too, because the 12B6, 12B1 is not a responsive pleading.
You're right. You're absolutely right. And he'll tell you, Brandon will tell you, what's the main thing they do, Brandon, when they respond? Aren't they outside 100% almost of the time of the pleadings? They're not talking about anything in the complaint, the four corners of the complaint. We talk about the four corners. We're talking about he's got to be addressing what's in your complaint, not what he thinks important. He can't bring up things he thinks is important on the side. He's got to address your complaint. And guess what? Anything he doesn't address in your complaint is admitted, okay? If you don't address it, it's admitted. That's in the rules of civil procedure. But attorneys are famous for this. They'll talk about everything outside of the complaint. They try and, Steve calls it a pro se trap. They'll try and drag you into this crap and get you arguing about nonsense. No. And you see my curt reply. You see my response where we pretty much said they have trouble understanding English, things along those lines. We stayed in the four corners of the pleading. We're not moving outside of that. You go talk about anything you want, Mr. Attorney. We're going to keep you right here. And if you're not talking about what's in here, you got a problem.
Well, and I haven't met one yet in the wild that doesn't apply the same tactics. And we'll talk about this because education has been captured here in the United States for the last 60 years. For every 10,000 law students that graduate, there's probably only 3 or 4 that actually care about the Constitution. The rest are called critical legal theorists. Okay. As a matter of fact, I've shown y'all the Bar Association critical legal theorists and their goal to transform, I always hear this word, transform the institution of America into their idea. Well, their idea is communism, okay? And it's being done through the many associations, but the Bar Association too. They're one of the worst offenders of this, and that's why when you go to court against one of these administratively trained guys, all they do is bring stuff outside, and they'll talk in circles and incriminate themselves. And here's the thing: make genuine, materially false statements over and over again without any evidence on the record. An attorney just talking on a motion 12B6 without any discovery or affidavits or anything else signed by someone who was actually present is just hearsay. Okay, that is what it is. It is just an attorney talking in circles. And once you grasp that and you see through it, you won't get stuck on the mud. And what you'll do is you'll dial in. Okay. And this is the purpose of this, because judges are wanting to, I'm noticing this with many people, the American First Legal Team, the Missouri versus Biden, the Pacific Gulf Company, the Institute for Justice. I'm following all kind of cases from a plethora, even lawyers, by the way, even attorneys and groups that are constitutional law attorneys having judges and clerks just sit on their stuff. Brooke Jackson, the Attorney General, took over her case, which is just crazy. But nonetheless, so you have to think tactfully, right? What can I do? Well, one of the things we can do is called a motion for a summary judgment. Okay, so and you can jump in anytime, Alphonse. So when there's literally no genuine dispute of material facts, okay. For instance, in the hospital case, 3 different motions to dismiss, okay. Every single one of the motions to dismiss, the attorney admitted that yes, they did exactly what the government told them to do by mandating the COVID policy and retaliating against my daughter. Oh, okay. Well, guess what? I'm sorry, you don't know what the public-private partnership is, and when a private corporation who I can prove through the public function test, doing duties only assigned to the government, right? So we have 0 genuine dispute of material fact. The rest of it is colorable. I'll use the word colorable. So now we can convert that motions to dismiss into what's called a judgment on pleadings. Okay, let's go ahead and move this forward. I'm going to set a hearing for mine. Let's go talk about it, right?
Steve said, here's what you do, dude. When you go in and say, let's pick a jury. Let's get this on the road. Let's go to trial, because they don't want to go to trial with you. They don't.
No. And all they're trying to do, they see pro se, the first thing they're going to do is throw the motions to dismiss at you. Yeah. And your first time around, you're going to freak out a little bit. But the more you actually read and look, I advise everybody to go read the case law that they're citing. We found 2 blatant mistakes with U.S. attorneys. One, she cited a case out of New York that never had the filing fee paid. Whoa. It was dismissed for not paying the filing fee of a pro se litigant who was in jail. Okay. The second one changed the language within the 1871 Ku Klux Klan Act. And very small, but you got to pay attention to details. Race-based. She quoted a case law. All right. There was one word that she changed. Race-based. It reads, or class-based invidious discriminatory animus. Guess what word she changed in that, Alphonse?
Or. She changed or.
She changed or to and. That's criminal. It's criminal. Let's talk about your summary judgment.
Plausible deniability. She'll say, "Well, I made a mistake." Well, no. You're an attorney. You're responsible for understanding what you're filing. Okay.
Well, no, she's right. Okay, in Westlaw, when you're in Westlaw, when you right-click, when you copy and paste out of Westlaw, it gives you copy with the standard. Okay, which means the current case law, it copies it all. No, she went in there and changed it.
Changed it. Yeah, it's funny, and like when Brand was talking about the attorneys, so my property tax suit, I sued the county, the tax bureau, and there's 3 individuals I sued: the property tax bureau manager, the local tax collector, and the head assessor for the county. Well, guess what? They never read the suits, Brandon. When they got the suits, they handed them over to the solicitor, because I had people from my group call up and got a hold of the assessor, and he said, "Did you read the suit?" No. He handed it off to the solicitor. The solicitor also was not qualified. The solicitor is the law firm that handles the county's business. They had to hand it off to another law firm in Philly. So here's what's happening. The people you're suing have never read the suit, okay? They have no clue what's going on with the suit. They got an attorney speaking for them, and he's out there talking about nothing in the 4 corners of your complaint. He wants to file a motion to dismiss. He's got to address what's in the complaint. He can't go off on a tangent of what he thinks your case should be about. Doesn't matter what he thinks your case should be about. It matters what's in the 4 corners of your pleading. And if he's outside that, now he's not putting up a defense for his client. He's trying to, we call it a stall tactic. He's trying to delay and stall people doing this. That's exactly what it is.
let's talk about that too, because what I find in each and every single one of the cases is intentionally delaying the proceedings, increasing the cost of litigation. Okay, and like this, what's the other one? There's one more that is a sanctionable offense, but it's every single attorney that I have gone up against. Now we got 1, 2, 3, 4. We had 4 attorneys enter pro hoc vice. Got one. That's 10, 11, 12, 13, 14. We've got 14 different attorneys in our 5 different cases. Okay. And or 6 different. I can't remember how many it is, a bunch of them, but nonetheless, 14 different attorneys. Okay. And not one has told one truthful statement. Not one. That's a pretty, not many people go up against that many attorneys in their entire lifetimes as a pro se. That's a pretty picture view of what you're going to be up against. Okay. And out of the 1, 2, 3,
but that's
4,
the rule. That's not the exception. That's what they all do.
Oh, this is the rule. This is the rule. The exception is your honest guys out there. Yeah. Your exception to the rule is those few constitutional law lawyers out there. So, Missouri versus Biden for the censorship. You got the American First Legal doing all their stuff. You got Institute for Justice who's going after all the property stuff. But they're the exception. Look, I interviewed 40 lawyers calling them on the phone about my daughter. Oh, we can't win that. What? It's an open and shut discriminatory violation out of Title VII of the 1964 Civil Rights Act. It's $300,000 freebie. What are you talking about? You can't win it. But they're also ideologically aligned with the so COVID narratives or the climate change narrative or the transgender narrative or all these other narratives, because they are deeply ensconced in their own religious ideology. And I have yet to face an honest person with it.
And here's how stupid their actions are. Brandon, how much money would your daughter have taken to make this whole thing go away?
10,000. She would have took 2, 3 thousand. She would have just took anything. If they gave her anything, she said she wanted to quit.
But what do you want? Let's say 5,000. Would she take?
Oh, she would have gone. Oh, she.
Brandon, how much money have they spent fighting you now in court?
Oh yeah, at least upwards of 50,000 at least. At least.
Does that make any sense?
No. The Choctaw Band of Indians. Okay, the Choctaw Band of Indians. Me and Gary were going to settle for $20,000 off the rip. We're 2 years into this lawsuit, folks. How much money do you think this top 500 attorney in the United States is charging the Choctaw Indians? Well, we're upwards of $250,000.
Could have made you go away, right? 50 grand could have made you go away.
Just go away.
They love spending money, man. They love just burning money.
Well, and on our side, though, the longer it takes, the more we're going to make too. Because there's 2 ways. I think it's Title 18, 1247, which is one way to get for pro se to get.
We should get compensated for your time.
Attorney's fees,
Sure.
and then you can do a Rule 11. It's a sanction. You're not actually sanctioning anybody specific. But for the litigation fees and the fact they fought you all the way through, you can do a Rule 11 sanctions to get your attorney's fees out as a pro se. So just remember that, guys. As you move forward, you need to look into these things. And as your litigation moves forward, know that you need to be keeping a tabulation of the time. Hey, look, I'm up for it.
Is your time any less valuable than his?
What's that?
Is your time any less valuable than
his?
No,
my time's more valuable.
Why can he bill $400 an hour and what, you don't get nothing for your time? You just waste your time, your life, and you waste your time and you don't get nothing.
Well, I'd say the time I spend on this is more valuable. I work a full-time job. I got two children. I do a lot of stuff. So I got to cram pack a lot in a couple hours in the afternoon. Oh Lord. But so let's talk about your let's go back to, because me and you had about an hour and a half long conversation last weekend, and we were talking about maybe going default judgment, and then they started talking about the summary judgment process. And let's talk about one of the things that it's unfortunate. It's in American jurisprudence too, and case law. So if a defendant gets an attorney and plans to defend, the court is not going to look happily on your default judgment, which kind of sticks your hand, right? Because, for instance, I'll give everybody an idea behind this. Right now, I've got a case against Wildlife and Fisheries and Continental Land and Fur. One attorney has filed motions to remand, and like 6, 7 motions that are just plumb retarded. By the way, my controlling cause of action at the top is Title 42, 1983. This attorney has wasted 70, 80 pages, motion to remand back to state court because the federal government doesn't have federal jurisdiction over a Title 42 claim. Anyway, but on the other side, I've conferred with the attorney for the state of Louisiana, who hasn't filed anything. They haven't even filed a reasoning behind why they're not opposing the motion to remand, yet they moved it to federal court. So what I'm going to do, instead of the general 60 days, I'm going to wait 90 days. And I'm just going to let it sit there because there's, by the way, if anybody ever faces this, and thank you, Gary, for finding this. An Article 3 judge is the only type of judge that can rule on a motion to remand, by the way. So it has to be an Article 3 judge. So the magistrate, he's just sitting there looking at that motion to remand, can't do anything. But anyway, so I know that this particular case is in a different spot. I'm kind of in limbo. I'm going to do a default judgment, and all they're going to do is the attorney's going to come in, but nobody has filed. It's been April 19th. Nobody has filed a responsive pleading in this case. So I have to come up with something. And this is where the summary judgments come into play if you've gotten a motion of 12B6 or 12B1. Because the motion to 12B6 and 12B1 instantly pushes the court forward as a judgment on the plea. Take us through your train of thought last week, Alphonse.
With what what my attorney's been, the guy that I'm facing's been doing?
Yep.
Well, listen, he knows he can't answer the complaint, and he'll argue that it's too long. My God, it's 149 pages. Well, no, it's 92 pages, and it's got to be 92 pages. Why? Because there's 8 counts in it, and there's 5 defendants, okay, that have broken a whole lot of laws. So, listen, the more laws they break, the longer the complaint's going to be. I can't bring it down to 10 pages if they're breaking this and breaking that. So he can't answer the complaint. So here's what they do to you as a pro se, okay? He's going to try and pull you outside of the 4 corners of your complaint. He's going to file a motion to dismiss, which he's going to bring. 12B1, 12B6, they're all standard. You're going to get them continuously, okay? It's like Steve said, he's got to file that motion for one reason, to show his client that he's trying to do something, okay? He's got to justify the money that the county's paying him to show he's trying to do something. So he's going to file a motion to dismiss, some crappy motion, and he's going to try and argue outside the 4 corners of your complaint. He wants to drag you down some road you don't need to go. And your whole goal is to survive the motion to dismiss. Because when you survive the motion to dismiss, now he's got to give you an answer. He's got to give an answer to the complaint. When he gives you the answer, now you can pull him into discovery, okay? Now you go through the 5 elements of discovery. You get to do admissions, interrogatories, request for production. And like Steve said, I pray that they'll put an assessment in your lawsuit. He said, I'm dying. Please put an assessment in the lawsuit. Why? Because now we got them for filing fictitious documents into a federal court case. They don't have no assessment. So the lawyer, he tries to skirt away from it. Like he won't address the assessment or the return in the suit. Why? Because he can't. Because that's the actual law that we're banging over the head with. He didn't want to talk about that in the 4 corners of the complaint. So his first thing when he filed that motion to dismiss my case, he was trying, like Steve said, it's a pro se trap, they call it. He's trying to pull you outside of your complaint to get you to argue about irrelevant matters. And if you read my response, you can get on my Telegram group, my response to that. I would say it's rather curt and direct, okay? And sort of smacks the attorney around in a nice legal way that he don't know what he's doing. He has no idea what he's talking about. And we don't need to respond to any of this because he's not in the four corners of the pleadings. So now he files that motion to dismiss. So he's sitting on his hands thinking that he don't have to do nothing more. No. That's not a responsive pleading he's filed. He's not filed a responsive pleading.
Tell him what it is. It's a dispositive.
You're right.
It's a dispositive.
So he's got 60 days. The clock's still running. He missed his 60-day window. Steve thought he was going to hit the last day. I said, no, this guy, he's out in La La Land. He thinks he's good, okay? He never filed an answer. Great. Now we get to move for what against him? Motion for summary judgment, you know? Listen, he when he filed that motion, Brandy's told you can move a court to do anything. So if I'm filing a motion in which I just filed motion for summary judgment, guess what I'm going to do in like 6 or 7 days? I'm going to call the judge's assistant up, and I'm going to request a motion hearing. I want a motion hearing on my motion. He didn't do that because he don't want to go before a judge and explain how his dumb arguments of I don't own the property, which is just the ridiculous claims. He has nowhere to go. So he don't want to go to trial. He's trying to bully me around and hope I do something stupid, and that has not happened right now. So like Brandon said, I filed a motion for, we call it a summary judgment, basically. In other words, it's not that he didn't file some kind of response of anything as a response. If they don't appear or they don't file any kind of response, then you can go to the clerk to get a default judgment. But if they file anything or they make an appearance, now you got to go to the court. The court's got to basically work the default judgment or the summary judgment, and they're pretty much the same. I don't care what you say. If you don't file a responsive pleading, it's still a default. Now, listen, there are, like Brandon said, there are no facts in dispute. Why are no facts in dispute? Because the attorney never filed a responsive pleading addressing what's in the complaint. He wants to talk about what's outside the complaint. That's not a responsive pleading. That doesn't qualify as a responsive pleading. And it, like Steve said, and even Randy Kelton said, and Steve commented, Randy said the same thing. Just because you file a motion, it doesn't freeze everything. In other words, nothing just the case don't get suspended for 6 or 8 months because he filed a motion to dismiss. No, he never set it for a motion hearing. He failed to defend his own motion. He could have requested for a motion hearing. Like, what's rule number 1, Brandon, from Dr. Graves? Don't move the other guy's case, right?
That's right.
I mean, he's jumping in my Telegram group going, well, he filed a motion. When are you going to have a hearing? I don't know. I don't care, okay? I didn't file it. Why would I set a motion hearing for his motion? That's not my responsibility. It's his responsibility to move his documents. It's always the other party's responsibility to move their documents. Don't, like Mr. Dr. Gray says, don't move the other guy's case, okay? If he didn't ask for a motion hearing, I ain't going to ask for it. But I know it's the clock's still running. And that's where we got the summary judgment thing from. And this is a very common practice you're going to see. He's running into it now. I know people in my Telegram group are running into it now. But at least in Tate in our group, at least his people, the people he was fighting, when they filed the motion for motion to dismiss, they actually asked for a stay. They requested a stay until the motion can be heard. In other words, they know that the clock was running. The response clock was running. So they didn't just file the motion to dismiss. They requested a stay until he could have a motion hearing. My guy didn't do that. He's special. He didn't need to do that. So listen, you're going to get attorneys that I don't care what experience they have. You're going to find out, like Brandon said, they operate outside of the rules of civil procedure, which is actually your friend. When you're in the rules of civil procedure, they're your friend because it's no longer you saying it. It's what the rules say. And if you get an incompetent magistrate like Brandon's running into, he's got a magistrate that wants to act like a judge. What are certain things that magistrate cannot do, okay? So if you're following the rules and that magistrate does something wrong, or even that judge does something wrong, well, now you're primed for an appeal. You got a handed appeal right now because the rule said this, the other party didn't do that, and the magistrate or the judge overlooked it. So now you're set up for an appeal. Eventually, you're going to get an adult's going to go, no. The rule said this, they didn't do it. You can't move this like this. So that's what he's talking about. You're really setting your case up for an appeal. If you can win the trial court, great, but don't plan on it because there are a lot of incompetent magistrates and a lot of incompetent judges you're going to run into.
Yeah, and while we're talking about the rules of civil procedure, for anybody out there that has bought, their rules of civil procedure book, I would highly recommend the Casebook Supplement Edition, and I'm going to explain to you why. I cannot count how many times I started reading my rule book and got to the case book, the case law supplement that explains the rule, that I have found an answer that I was looking for. Of course, I have the luxury of getting in onto Westlaw once I read the case, here a snippet of the case, and go verify. But nonetheless, it will help you greatly in understanding. For instance, me and Gary and I, 2 weeks ago, I'll just give, and thank God for Gary. And I hope, and another thing, while we got this up here, let me go off on this tangent. We've created the groups to help each other. One of the things that I'm greatly disgusted with is the inability of our groups to get focused and to assist each other, but also the allowance of the outside noise to constantly come in. And what do I mean by that? Our opponents, our real opponents in this reality, are laser focused for the objectives. It doesn't matter if the revolt is in Charlottesville or Alaska. The loonies are there and they're funding each other, right? We don't have that on this side of the aisle. It's one of the things I will talk about greatly. But the purpose of the groups is especially for Gary and I, we've been in the courts for 2 years now. You can learn a great deal from our mistakes. That's the purpose of it, to help each other along, right? And so, yes, you have to anticipate that your case isn't going to go into court and it's just going to instantly be ruled on. It's not going to happen unless you got a great judge or a great set of judges. The only case that I wish more of our cases were going through the Southern District of Mississippi with the great clerk's office there. Case in point, we mailed a summary judgment there on the Mississippi Band of Choctaw Indians. The day it was received, that was the day it was filed. We don't have that in the Middle District. But anyway, nonetheless, getting back on point here, guys, you're going to be tested, okay? And you've got to push through. You got to have this mindset, a fortuitous mindset, which means you're going to persevere in the face of adversity, and understand and grasp that. For instance, the one attorney that watched 3,000 hours on my YouTube channel. What did that? Right? I think it's Rule 901, Federal Rules of Evidence. My religious beliefs are not up for debate. I'm pretty sure it's Rule 901. But nonetheless, I think it's 901. I can't remember. No, it's not 901. But anyway, there's a rule in the Federal Rules of Evidence that your religious beliefs aren't up for debate inside the courtroom. So all that stuff about what I believe about communism and everything else that he kept watching was irrelevant and non-competent to the case. This is what they do, right? But you're going to face this over and over ad nauseum again. While we're at it, anybody who's wanting to get into this avenue, and I'll say this again: law, justice, morality, and truth all go hand in hand. Okay, we cannot disregard the rule of law and have a just society. And the reason for that, we can go all the way back to William Blake Stone's writings. Right, absolute rights do not bend to the municipal law unless it breaks the civil code. What do I
What
mean?
year was that said? Ballpark when that was said?
Yeah, I've got it in my phone. I'll tell you.
Funny he said municipal law.
Oh, yeah.
That's what we're wrong. That I'll tell you, the most dangerous people in your life is your local municipality and your county are the two most dangerous legal entities in your life.
Here, I'll read it to you. This is from William Blackstone, folks. I posted the link to this not long ago. Now, the rights of persons that are commanded to be observed by the municipal law are two sorts. First, such as are due from every citizen, which are usually called civil duties. And secondly, such as belong to him, which is the more popular acceptation of rights or jura. And I'll skip down a little bit. And then he goes into the persons are divided. Then he goes on into, by the absolute rights of individuals, we mean those which are so in their primary and strictest sense, such as would belong to their persons merely in a state of nature. And this is a huge issue where Tanya Jackson, the new Supreme Court deal goes, she doesn't understand the law of nature. Of course she doesn't understand the law of nature because it's based on principles and how we interact with each other, okay? In which every man is entitled to enjoy, whether out of society or in it. But with regard to the absolute duties which man is bound to be performed, considered as a mere individual, it is not to be expected that any human municipal law should at all explain or enforce them.
You know what's fascinating about that? You know what's fascinating about that? He wrote that long before municipalities really blew up, okay? Right now, when he wrote that, municipalities were nowhere near as oppressive as they are now. They're on a whole different level right now from where he wrote that. And he's seen that back then. He was talking about that. He picked that up.
Yeah, this is 1753.
Look at that.
1753. And what you have is these cycles. It's late 1860s after the Civil War was one of these cycles where which is the origination of the Ku Klux Klan Act. By the way, we'll go into a little history discussion here. Everybody needs to read that act, and the history regarding that act had nothing to do with a race organization. They were a political terror organization killing any Republican at the voting booth, including judges and clerks. Okay, kind of like today with the extreme left and the woke. They're political terror organizations. Okay. And that's what's going on. It's the same cycle. 120 years later, here we are again. We're Democrat, and the actual name of the Ku Klux Klan was called the Democratic Socialists, by the way. I bet you people didn't know that.
Listen, you got to understand that this is a chess match you're involved in. So when I filed that motion for summary or default judgment, I don't think some judge is going to turn around and sign that. I'm under no delusion that that's going to happen. But here's what the purpose of that was for, so that I could push that to a hearing, so that I could push him towards an answer. I want to push him towards an answer. So I'm just moving a chess piece along the board. I had to wait. People are saying, what's going on with your case? I said, it's not my move yet. 60 days still going on. Not my move yet, okay? I had to wait. I couldn't say nothing. Had to let him sort of default, and then I could come and file. Because I'm going to push him towards an answer to where a judge is going to say, hey, listen, Mr. Attorney, you got 7 days to file an answer here, or I'm going to give him the default. I want to get him to an answer, because when he's got to get to an answer, we're going to go to the settlement table. Don't kid yourself. He's not going to trial with me, because they will lose in trial, and then we set precedent in Pennsylvania. Not only Pennsylvania, we set precedent throughout the country for every county. They go, see that suit in Pennsylvania? What just happened? Oh my God, that's fraud that these counties are doing. They cannot go to trial, because when they go to trial, there's going to be a call from the governor's office or the inspector. Somebody's going to call and say, make that go away. Make that matter go away, okay? We don't want this on center stage. So it's a chess match. You know, you're doing certain things, even though you know this is probably not going to do what you really want it to do, but you're moving them. You're moving your pieces around to get them in checkmate. That's all you're doing. So you got to understand, you know, that just because you file something, it's not that you're going to get it, that the judge is going to sign it. but it's going to force the judge to move the player in another position he don't want to be in, because he's got to come in and explain why he didn't answer the complaint in 60 days. The rule says he's got a 60 days to answer. He didn't answer. Why didn't he answer?
Give me some feedback on that, Tribe. I turned my mic down a little bit, see if that helps. So I do want to talk about this type of mentality right here. Look, Peter Birdsall, I'm not going to beat you down any further than you're beat down. I'm going to try to lift you up with some constructive criticism right here. Okay, so your preconceived notion about a court cult of Saturn under a Babylonian system is from somebody outside speaking against the fundamental principles of this country who want them destroyed in the first place, okay? And make no mistake, you haven't read the Federalist Papers, the non-Federalist Papers. You probably haven't read the Constitution. You probably haven't read any of the latest rulings from the United States Supreme Court or the Fifth Circuit, Ninth Circuit, 11th Circuit, things of that nature. However, yes, but justice is not handed to anybody. It must be actually fought for. So there is no victory without sacrifice. And let me state that again. There is no victory in the face of ideological zealots that have been here since the beginning of time. There's always some new cult wanting to restrict the freedoms and liberties of other people for whatever reason. There's always this group. You go throughout the annals of history, okay, and you will find another group. For instance, the Pythagorean cult, right, who had the spiral of Theodorus. It was a cult that ruined the previous philosophies that were coming out of, I think that's Greece, right? And then you had the Stoics like Cicero and things of that nature that were later ruined by other intellectuals that come along and sat in their rooms, figured out different dialectical ways of thinking, right? And it's always against reality. So when you say something such as this, you're already defeated. I'm going to state that again. When you ask a question such as this, you're really not asking me because I'm in the courts. You're making a statement, and you've already made your reality that you can't win. And that's a bold-faced lie from the pits of hell. Everything shall be given unto him who is a true seeker of knowledge. Okay? We can't just lay down at this time frame and allow the 17 sustainable goals of the UN to come into effect in 7 years. We are in a critical time where we need more people getting into the courts, getting active, helping each other, and stop this. Look, folks, this is utter madness where we're going. We have the lowest literacy rates in our nation's history, lowest math rates in our nation's history. We have education centers pumping gender dysphoria, flurry crap, and all that stuff. And then we've got the next pandemic, and I'll make this declaration now. The next pandemic is climate. That's where we're going, where we're heading, because the entire UN 2030 agenda is wrapped around education, which is indoctrination, by the way. When they say educate people, they don't indoctrinate them, and climate. Okay, we got to bring carbon net zero, right? All these ideas, you got to stop inhibiting yourself from moving. Your inaction is actually your action. Okay, that's all I'm going to say on that.
Peter, let me just say this. Listen, here's what I love about these conspiracy guys. That it's a Saturn, it's a cult of Saturn. Listen, I've talked to these people one-on-one, numerous people, okay, in government. They wouldn't know how to tie their shoe without looking at their attorney, okay? So these are not people of a cult, okay? These are basically incompetent people that are mistrained, that don't understand the law, that get these jobs and are told, you do this, you do that. They don't know why they're doing it, whether it's legal what they're doing. They just get these jobs and they tell them to do this. When you actually sit down and talk to these people, which I've talked to numerous of these people, these are not cult people, Peter, okay? These are not people that know anything about any cult. These are people that got some job and they were told, listen, you get this list, you send this tax bill out. They don't know whether you're a taxpayer or not. They don't understand the tax law. They understand nothing, okay? This is not some secret society control. Know what the secret society control is? That you would believe that crap, that you will go down that road to believe that crap, because guess what? What you just posted there is of no help to you in any way. I know guys that have went to court and won multi-million-dollar settlements and batted people around, okay? And it had nothing to do with cults, nothing to do with secret societies. It had to do with the actual law. And it's really no more complicated than this. Either someone has a right to do something or they do not. It's really no more complicated than that. And if you're good at drilling down when somebody says, hey, Peter, you got to do this. If you're really good at drilling down to find out under what authority are you claiming I have to do this or that, that's how you do this stuff. This is how you bring lawsuits against people. When you can take a statute and break it down and understand things like justum generis, and what's the other, nosicator, what's the other a Latin phrase that I can never get? When you understand the context of statutes and how they're written and how to prove that there's no way that statute could have been written for you, because the subject of that statute has to do A, B, and C, and you don't do A, B, and C. So there's no way that was meant for you. It's nothing to do with secret societies. You're not going to get anywhere with that. Listen, you can believe that all you want. You're going to be stuck as a slave the rest of your life, okay? Well, if you want to live in that mindset, you're not going to get anywhere. The way place you get anywhere is guys like Brandon, me, and Steve, whatever. You're out there suing people. Because once you start suing people, guess what happens to you? You become a very unpopular guy in your county. They no longer want to interact with you or bother with you. Because why? Because you'll turn around and sue them. And you're not some free man on the land talking about secrets of Saturn. You're not suing them for that. You're bringing the actual law and banging them over the head with it. And you're bringing cause of action and proof of damages that they've done to you. And you're suing them what, Brandon? Their official and their individual capacity, which means now their home, bank account, and business are at risk because now you're suing in their individual capacity. Has nothing to do with Saturn. Has to do with learn the basics. Stop listening to these guys and empower yourself. We all haven't, like I told Brandon, we got an F-35 jet sitting on my driveway here, okay? We all got this F-35 jet. Not 100 charging over the hill to get you, and you can't even climb up the ladder to get in the cockpit. Because why? You can say you have rights, and if you don't know how to exercise them, you got zero rights. You got to know how to exercise your rights. And what do we say, Brandon? Unless you're doing two things, you're wasting your time. Unless you're writing a complaint, okay, putting a pleading together, and learning how to litigate it, they're the only two things you need to do. Learn how to write a complaint, a solid bulletproof complaint, and learn how to litigate it. Anything else you're doing, you're wasting your time. It may lay groundwork for stuff, but you're wasting your time unless the things you're doing are not involved in writing a complaint and litigating the complaint. I'm done with my tirade.
Well, hold on, let me do this. Be Sibley 97 at Gmail, and I will invite you on one of these tribes. We can do that. Yes, turn your. Can you turn your volume down one or two notches? Let's see if that gets rid of the feedback loop. And so, yeah, there we go. The Birdall. You don't know the origination of the courts. Up until the common law in England, courts were ruled by totalitarian dictatorship, right? That's why we have the separation of powers doctrine here, and we have due process, where the judiciary is independent, right, of the executive branch and legislative branch. So with that, I would tell you to quit going to Johnny Tutu's blog and reading what he claims is going on. Now, I will not ever excuse the incompetence, the ignorance, and the overall zealotry of people who are pushing a certain agenda. The courts aren't doing anything to you. The courts are just brick and mortar buildings. When you walk into a court, you're going to have a judge, and then you're going to have attorneys. Each set of these people have unfortunately went to higher education in the United States of America, where they were indoctrinated and dumbed down to believe that constitutional law doesn't matter. However, it's the highest law in the land, and none of them get educated in common law. Okay, so when you grasp that totality, then you can get out of the weeds with all the bull crap. It's not about a Saturn cult. We got plenty of death cults running around right now. You want to worry about a death cult? Watch these mothers and fathers mutilating their children with sex change operations and things of that nature. It's right there in your face. You don't have to hypothesize by it. We got the COVID-19 vaccine. That was another death cult right there. The masking. You've got plenty of stuff that you can verify with your own eyes, have firsthand personal knowledge, and not have to go off the hearsay of somebody else. If I can teach anybody anything, do not read everything you read on the internet is not true. All right. And now let's move into, are you ready to move into questions and answers?
Yeah, let's go.
Let's go, guys. So everybody, if you've got questions, please feel free to ask them. Now's the Q&A section. I think we're all caught up on our current tactics and litigation tactics and how we're moving forward. Quite possibly the only one that we haven't spoken on is the case that's in appeals right now. But Brother Gary wrote an excellent appeal, beautiful appeal. I don't see how it's not remanded back to court with so many judicial errors. Okay, well, maybe I just need to talk a little bit lower, Mr. Mike. But we'll get through it. We'll push through it. We'll get that hashed out. All right, Q&A. I already hit all that tribe, by the way. All right, I guess we don't have anything. That's the first. And Alphonse, you win the bet tonight.
Yeah, I said 4. I was my 4 is the over and under. Okay.
Yeah, you won the bet tonight. I don't know where everybody's at, but we didn't get any. It doesn't look like it, did we?
No, not really. No. Well, it's Saturn. I would say that's 1. Okay.
Well, it's just success stories.
And listen, Brandon will tell you. Listen, I mean, dude, I've given up count. Okay, and it's just little things too. I mean, you're looking at big things. Yeah, a couple of months ago, I got a guy $300,000 settlement for had to do with a will. They try to kick him out of the will. How did we bring it to a head? We filed a motion to show cause why the sister shouldn't be held in contempt for perjury because we caught her in a perjury trap. That's what brought the case to, because they wanted to give him 0. And by the time we filed that motion for default, for the motion for to show cause why she should be held in contempt, because we caught her in a lie to the court. She lied about the money that she took from the aunt and the money that was in the estate, and we had proof of it. We had we went to the broker's records. We got the records from the broker, and we got the jewelry appraisals, and we showed that she was lying. We filed a motion for. This is all basic stuff we're doing here, Brandon. Nothing special. It's in Dr. Gray's course. Motion to show cause why she shouldn't be held in contempt. Within a week, the lawyer settled the case for $300,000, and he could have got more, but he said, "I'm tired. 2 years we've been fighting this." He went away. There's a million little things like this. Brandon's had a ton of successes. We lose count. What I love about our groups is there's always a success story coming up, whether how minor or how major it is. And the best Brandon knows, he'll tell you, dude, how many things have got people like, I got my kids, I got full custody of my kids today. You know, yeah. I've got a few of them, you know. The wife wanted an increase in the alimony. I fought her for custody. I got full custody of my kids today. That's to give people just a little bit of knowledge that they take and run with, and then you're changing their lives as far as their family. We didn't do it. Me and Brandon just sort of opened the door for them to say, here's what you do, here's where you go. And they took it and ran with it. And to me, that's the greatest thing is to see that somebody like changes their family, you know, gets their kids, custody of their kids.
Got a few EEOC claims and things of that nature where they settled right out. There's always those success stories. However, especially with the 5 cases that we're involved in, these are high-profile cases, folks. And I look to change the entire complexion of the public-private partnership with this. Eventually, Gary and I are going to, well, we already have included the Patriot Act in our pleadings and the administrative code. I look to take down a notch of this entire system. The rule, if you go read the Rule 52 motion, you'll see that I'm going after the administrative state. There's a reason for that, folks. These things aren't going to be ruled on tomorrow. All the COVID cases, the first one that's going to be settled on that is going to be my daughter's. That'll be the easy one. The rest of them are not that easy, right? These are going to be long cases as far as my cases go. The only one that's a clear and blatant violation of the Fourth Amendment is going to be the Wildlife Fisheries Continental Land and Fur. They have no warrant. They had no affidavit of probable cause. So that one will probably be one that settles way before these bigger cases. Even the Choctaw Indians, I don't think people recognize what we really intend to do there either. Having these entities in bed receiving $1 trillion from the federal government or $1 billion from the federal government and acting like they're sovereign this doesn't work for me either. You want to be sovereign, you'll be like the Amish and the Mennonites, not accept government handouts. So with that, I'll answer this next question. Isn't it a conflict of interest since you're not a bar associate, but they are? Lawyer, prosecutor, and judge. Okay, so the prosecutor would be for a criminal charge, and a lawyer in our cases would be a civil lawyer. Okay, so that's two separate things. However, it's not a conflict of interest. You're going to walk into the court with the most power and most authority because you are the only one that's going to be standing in there in front of the judge that has what is called firsthand personal testimony. Okay, the rest of them are going to be talking in circles and everything else, and you're going to have the rules, you're going to have the law, and you're going to be able to testify. And the other jerk off over there, whenever I pray I get to one of these oral hearings soon because it's just going to be nasty. But nonetheless, it's not a conflict of interest. A conflict of interest would mean that I'm having payments from somebody else, right? That would be one conflict of interest.
Listen, Norman, the reason we do this, your main goal when you file these federal suits is you just want to survive the motion to dismiss, and that's not hard to do if you have standing. When you survive the motion to dismiss, well, now you have to get an answer from the other side. When it gives you an answer to the lawsuit, now you can move into discovery. There's 5 elements of discovery, okay? Here's the power of discovery. You can write all the letters out of court you want. They're going to ignore your letters out of court. They don't care about your letters. They don't care about your affidavits. They don't care about nothing. Guess what they can't ignore, Norman, when you're in a lawsuit? They can't ignore discovery. When I ask them admissions are yes/no questions. So think about this, Norman. Think about how'd you like to have your opponent on the opposite side of you, and you could ask them any yes/no question you want to make them look as bad as possible. That's your admissions questions, okay? Interrogatories, where you can ask sentences. Hey, Mr. Assessor, how did my non-commercial property get on your ad valorem commercial tax roll? Please explain this to me. They're your interrogatories, okay? Now you do requests for production. Hey, Mr. Assessor, I'm looking at the Pennsylvania state tax laws here. It states that a taxpayer is required to file a return. Mr. Assessor, can you produce the return filed by me with you in this matter? He's got no return, okay? Well, he can't do an assessment without a return. Mr. Assessor, can you provide the assessment based off the return? And by the way, the assessment needs to have 3 elements. It needs to be market value, needs to be depreciation replacement costs, and needs to be income approach. Can you please provide the assessment showing those 3 elements that it must contain? This is discovery. This is where cases go to die, Norman, because when you got them in discovery and they can't produce these things, they can't go to trial with you because you pretty much won your case in discovery. Discovery is where cases go to die. If you know how to use discovery, cases go to discovery to die. You make their case, their defense, you make it die in discovery Because there's no way they're going to walk in court and go, we can't. Here's the law. It says you needed a return. We don't have no return from Mr. Faggiolo.
Well, in all of our cases too, right? One of the first things we're going to force the court to produce, right? In the United States Marshals, federal judge, and the law and security, produce on this date between this time the recordings of Gary and Brandon having to go through extra security detail. Produce the recording in the clerk's office on this date and at this time with an armed detail. Produce the recordings and the audio from this date when the head of Walden Security said it was a private memorandum from the United States Marshals that dictated we had higher security. They can't allow this to go. But once it's in discovery, we're going to eat them up because all these things are going to prove the point. Right? There's no private memorandum concerning citizens of the United States that have what is this, the Gestapo? But nonetheless, let's move to the next question. I love that is the goal of all this stuff and why it takes so long to get through the motions to dismiss, because judges really don't want to rule on it. They're sitting there going, man, if I open Pandora's box right here, especially with the COVID stuff now, especially with the COVID stuff and especially with the property stuff, they open Pandora's box here. Guess what happens? Now you have lawsuits galore coming in. So nonetheless, it's going to happen anyway. We're going to bankrupt this fiat currency one way or another eventually. So whether it's by them giving all the money to Ukraine or whatever, who knows? It's a topic for another day. What do you say? Bonker asks, what do you say when a judge says that they won't hear the Constitution? Okay. Well, first off, that judge's article.
Administrative court or judicial court, sir? Are you saying the Constitution plays no part in your court? Is this your statement, sir? I just want to get you on the record. I want to get you on the record, sir. Let him say no. The Constitution doesn't play a part here, because guess what? Administrative court or judicial court, I'll go wring his neck in federal district court if he makes such a ridiculous statement. He can do that to other monkeys. That ain't going to work with somebody who's going to march him into federal district court.
That's right. And so, Bonker, what I would tell you is to go back into our administrative procedure series that Alphonse and I did and get a grasping of the difference between administrative law and the law. And then you'll know what to say. Repeat that. Yes, I'd like to buy the record today.
And listen, if you really want to have fun with it before you even go to a lawsuit, go file a criminal complaint against them and go file a judicial complaint against them, okay? Now, they're not going to reprimand them for your criminal complaint or your judicial complaint. But here's what's going to happen. You're going to tap his insurance bell, okay? He's going to hear from somebody. He's going to get a call from somebody. He's going to hear from some people. And it's amazing how nothing happens to these people in state, but they just sort of stop bothering you. The matter sort of goes away, and they sort of just stop bothering you. So start using that. I would call that, Brandon, an administrative remedy. In other words, when you're using criminal complaints and you're using judicial complaints, right? You can move some things that way. Not guaranteed, but you get some people's attention. Here's what happens. They start looking at you and go, they're not used to seeing a guy like me or you file criminal complaints and judicial complaints against them. They're used to deal with the monkeys. They push the monkeys around. They tell them what to do, where to go, what to do. They're not used to the monkey banging them over the head and going, hey, wait a minute. I'm going to go mark your record up with a judicial complaint and a criminal complaint. That worries them a little bit, okay? They're not used to seeing that.
All right. So now this is a spiritual deal right here. So I'll take this, Alphonse. Brandon, how do I forgive a police officer that wrongfully arrested me for a serious allegation that could have seen me locked away for 6 years at least and a permanent criminal record? Any pain that you feel that, or any distress that you feel that is external, okay, is under your power to revoke at any time. That's Marcus Aurelius. I butchered that quote. Any distress that you feel that is external is not due to your is not due to the thing itself. It is due to your estimation of it. And this you have the power to revoke at any time. Quit letting the past haunt you. That's my live on, live and let live. I saw another question here that I wanted to catch, but it kind of passed me up here. I plan. Where'd it go? Just to get people off this subject. Look, the Gavin, there it is. Okay. Just before we even go anywhere off on this tangent with the fiat currency, listen. At this point in time, we have no idea what the goal is. I know the goal is to eventually have the digital currency. Okay, that's a fact. But you can't live your life like that because they're going to do the digital currency through the social credit score. You can't live your life. This is what we're in this fight against, to stop it. That way we keep our cash and we keep the hidden tax of inflation from killing us, because that's what's going on. There's a hidden tax called inflation also on every single one of us that's killing us. So don't get lost in the fiat currency and going down the rabbit holes. Let's focus on avenues in which we can rectify the issues in front of us. And I shouldn't have said anything about fiat currency.
Listen, I traded stocks, options, and futures, okay, professionally, okay? I did it for a few years, okay? Full time I was doing this. Listen, I've been hearing about this crash forever. They're going to do this. They're going to do. Listen, I've been hearing this since like 2011, okay? It's not going to happen. Listen, let me explain this to you. Listen, they're going to have crashes like they did in 2007, 2008, the credit crisis. But that's just the way to accumulate what. But I'm sorry, the whole system's not going to come apart. I don't care what these people are telling you. I'm sorry, it's not all going to blow apart. It's not going to happen, okay? They're in control. They can print currency at will. They can do anything they want. So forget about trying to plan on what's going to happen with this fiat currency. Forget about that. Listen, he's right. Brandon's right. And Steve talks about it all the time. They want to move all of us to a digital currency for one reason. Because when, like, tough guys like problems like Brandon and me or Steve pop up, Brandon, what are you going to do? They're going to shut your currency off, right? Now you got no physical currency to go buy food, to go do anything, right? And since it's digital, they'll just go into your account and tap it. They'll just pull money out of your account, you know? To me, that's the goal. They're trying to move us towards a digital currency.
Well, they are. That's why we have these conversations, because America must fall in order for this goal to be instituted. Okay, this is why we're teaching it. One, spiritually. I do the spiritual lessons and then the law lessons. And now I'm going to answer Angela's question. Do you feel that the energy and time you give to this effort is what God is leading you to do? The answer is unequivocally yes. An idle mind is a devil's workshop. There has to be something productive that we give our life to, right? This is an effort of love, care, and discipleship, where I see an avenue, because of much study. I see an avenue where I can use my pen as my sword before, and hopefully before the pendulum swings back too violently the other way. So yes. It's an altruistic form. I don't grift for money. That's one of the things that really means something to me. I do ask every now and then that people help Gary and I with the Westlaw, but I'm going to give you the information anyway. It's not going to be locked behind a password or anything. That's not what I do. It's never going to be what I do. It's not what Alphonse does. We truly want to see people become the strong individuals that everybody is capable of being. But this again, the law and the spiritual side meet right here. The only way that you're gonna be able to do this is be a strong, principally backed person and understand that wisdom is the key thing. And with all that get understanding, my children.
Yeah, Angel, listen, I consider myself, I like to think of myself as an angel with a dirty face, okay? I'm not going to be the prototypical religious, guy. I'm not that guy. But I can tell you this. After my mom passed away in 2019, I remember walking the dogs one day, and, I was just overwhelmed. Everything's coming down on me. The most closest people in my life were gone. And I said, hey, God, listen, I'll make you a deal. Let me be truly free, and I'll help as many people as I can, okay? And I can't explain to you how over the last 4 years, things have fallen in my path that it's just uncanny. People that I never thought I would meet, or like people that I used to look up to and listen to, became friends of mine, good friends of mine, okay? Not only became friends, became mentors of mine. Like, it's almost like they were placed in my path that for me to go through them and to learn from them. And I don't know if that would have ever came from, I think there's some kind of divine intervention, because I'm not the smartest guy in the world. Trust me, I'm not. But it just sort of, things clicked for me and things sort of came together for me. And like Brandon said, we're not grifters. And listen, Brandon could run a channel and charge like a lot of people do. He could charge a fee to be a member of his channel, and he could sell you documents, and he could sell you consulting fees. And we don't do that, okay? Jesus, I wrote a property tax suit, 92 pages plus exhibits that I gave away for free. Well, guess what? There's a lot of people out there would have charged you a couple $1,000s for that suit to show you how to gave it to you for free. Why? Because I want you to do what I'm doing, but I don't want you to take my suit and just slap your name on it. And I want you to learn what's in it so that you can be free, so that you can go tell you do it, and then you go do for your family and for your neighbors, so that we can stop what's going on in this country, so that we can put a halt to what's going on. And you got to get it in your head that the most dangerous people in your life is your local municipality and your local county, not your federal government. I really have no trouble with the federal government whatsoever in any matter. It's my local municipality and the county. So Brandon freely gives his documents. I give my documents. Gary puts his documents up there. We give our stuff away for free. I never charge anyone for a phone consultation or a document I've given them. Okay. I love when I get these phone calls or I get messages and say, I did this, Alphonse, this happened. I won this, I won that. To me, that's phenomenal, because I think Brandon's of the same mindset I am. We're not looking to give people fish. I don't want to give you a fish. In other words, I don't want to sell you some goods I got, okay? I'll recommend stuff that I use. I'll tell you, get it, because I think it's very helpful to have this in your toolbox. But we'd rather teach you how to fish, so that you don't need to come to me and Brandon to do anything, so that you have the same tools we have. You have access to American jurisprudence. You have access to whatever, Dave Merlin stuff, where 27 gigabytes of documents written that they're templates that you could work from. That looks like a judge wrote it. So we'll show you tools that we use. He's got a Westlaw subscription, okay? That's phenomenal. But he'll tell you, Brandon, isn't it like a car payment? Okay, it's outside the reach of the average person. But Brandon will take documents from that and information from that and share it in his group for free. He's giving it to you for free. And we're not out there to sort of grift and make money. We would love, we're not looking to be smarter than you and show we're smarter. We want you to do the same thing we're doing, okay? So not just me filing a property tax suit in my county. Why ain't there 200 more people behind me in Pennsylvania that got my suit? Why don't they slap their name in there and go sue their county? That's how you change this. You overwhelm them with the actual law. And that's our goal, is to get as many people as possible to do what we're doing. We don't want to hold your hand, and we'll help you, but we want you to be able to do what we're doing, so that you don't need me and him. And I've seen people do things, Brandon, I never thought of. Like I got people that were sort of like students in a way, and they'll do something and go, wow, I never thought of that. That's really
right.
And that's the great thing with human thinking, is somebody's going to take something I give them or Brandon gives them, and they may take it in a whole different direction than him or I would have. Hence the Dr. Graves course, jurisdictionary. Steve Emerson took that jurisdictionary course. That was sort of, the fundamentals. And Steve took that course in a direction and a level that Dr. Graves never could have perceived, where he's getting $38.2 million settlements for property tax suits. You can do that too. You could take something me and Brandon give you and probably figure out a way that me and him would never think about using and go, wow, that's really clever. That's our goal, is to try and get you to that point where you can do what we're doing, because we don't think we're anything special. Listen, I'm the guy, dude, here's the funny part. I'm in class one day, okay, with me and another guy, and we always mess around in this class, and the teacher pulls us out of class. You'll love this story. Okay? Me and him. He's so mad at us, he tells us, you two will never amount to anything in life. Well, the guy I was with, he's an attorney, okay? He turned out to be an attorney. And me, what am I messing with? I'm not an attorney, but I'm messing with law. Ain't that funny? The two people that would never amount to anything in life are tied up in law, okay? So you could do what we're doing here. I'm no smarter than you. The only problem with me, well, no, not a problem, but I have an advantage over you for one reason. I got in the mud with the pigs back in 2019. I've been rolling around the mud since 2019. I got a little more experience than you got. That's all. That's all I got over you is I got more experience. Not that you can't get that. You'll get it too. But take it easy. Start doing record requests. Start getting your feet wet. Start fighting a parking ticket, a traffic parking ticket, very low. Like there's very little risk. Go fight a parking ticket. Go fight a traffic ticket. Get your feet wet. Start doing this stuff. This is how you get this country back. You're not going to bring the system down with one big lawsuit. It's not going to happen. It's got to be a bunch of us doing this.
And that's it. And so we'll go to this next question here. In the interview that Brandon posted with Justice Scalia, he said, "I do not consider natural law at all in my decisions. Isn't that the basis of our Constitution and constitutional law?" Okay, so you hear that, but you don't grasp why Scalia said it. Yet in that same interview, he talks about going all the way back to the common law of England, William Blackstone, right? He was an originalist and a textualist, okay? All right. If it wasn't in a primary document, right, for the judge to interpret.
He was more than that. He was a soothsayer. He mentioned municipalities before municipalities were really a major thing. That's
right. And so what you have to understand is that a judge is supposed to rule by the limitations of government itself. So their controlling document is the Constitution. Now, you can always find the principles. You'll find the principles of the natural law in the Bill of Rights, in the Declaration of Independence. You'll find them in the Constitution. You'll find them in the Federalist Papers. You'll find them in the non-Federalist Papers. And let me say this for everybody out there. The Federalist and non-Federalist Papers are primary source documents. Back up. Primary source documents. They can be cited into your case law, into your case as primary source, just like a controlling case, okay? So that's why he said that. There has to be a writing for him to interpret. Okay.
Substantive rights are not, that's what that means. That's natural. Substantive rights. You have a right to exist, to make a living, and to shelter yourself. Okay. That's natural law. You have that's not granted to you by the state legislature. The state legislature doesn't grant you rights to own a property and to have a job. Okay. That's what the natural law is. It's your substantive rights, but it's in your constitutions. It's in your state and federal constitution. It's there. You're trying to. These people are splitting hairs saying natural law. Yeah, natural law is already there. You got to know how to exercise it, though.
Yeah, I just expounded on that, Mr. Fix. As an originalist and textualist, Scalia had to have a writing, which was a primary source document. I just told you that. Don't make it any more complicated than you can. Clarence Thomas is a natural law advocate. Go read his opinions, right? He'll state a principle that he believes in, but yet he's going to have the originalist and textualist identification of why this law doesn't, this set of rules doesn't work. Scalia was a devout Catholic, okay? A devout Catholic, a really devout Catholic, to be honest. And I've watched some of his interviews, of some of his testimonies at Catholic churches and things of that nature. But you have to understand the point. You can't just, as a judge, go off. Here's the opposite view. Why Scalia was an originalist and a textualist, right? Without the text to interpret, he didn't feel the judiciary had the right as an independent branch to put their own interpretations in, create this living constitution where the whims of the judges come about. This is how we got the war on poverty, affirmative action. This is how we got all this crap that he hated, that he absolutely hated, is because judges on the Warren and Burger court started the bull crap in the 1950s going up to the 1970s. Of course, I wish people would get more interested in this, going to read these great decisions. In 1952 was the first decision by the Warren Court, which took a man's wheat fields, 12 acres of wheat, because the Warren Court stipulated that even though the wheat was to be consumed on the man's land by his farm animals, that it had the possibility to affect the price of wheat in intrastate and interstate commerce. So they shut that man down from doing wheat. This was the impact of highly progressive left-wing courts, Supreme Courts, because they stand for more government. Okay, so when somebody is opposed to more government, such as Scalia, such as even Kagan right now, or Clarence Thomas and people of that nature, John Roberts, Oliver Wendell Holmes, and all these great jurists that sat on the judiciary in the United States, you need to reflect back on why they did ruled that way, because they weren't ruling by their personal ideological beliefs. They were ruling by the restrictions set forth in the Constitution of the United States, which is the way it is intended to be. Okay? All right. Anything else? Let's see. No. So, and I want to answer this. There's a young lady out there that I've helped who kept sending me documents, motions, and I read them, and I called her, and I said, "You didn't write this. How do you know?" I said, "It looks like AI wrote it." I said, "Well, I decided to use Chat GPT." No, do not do it. I caught so much wrong within that motion. I made her go back and write it herself. If you're relying on somebody else to do the homework for you, you're going to trust one of these programs that you don't know how the algorithms are put in. You got to be a fool.
I equate it to this, Brad. I came from the music industry. Okay, there's a program, pretty well known program in the music industry called Band in a Box, and it's one of them AI programs. You hit a button, it generates a song for you. Put some chords in there, it generates a song. Guess how many hit songs have been written by Band in a Box? 0. Okay. So hit songs are written by songwriters that start from scratch. Okay, and that's what you got to do in a lawsuit. You need to understand every element in your lawsuit. You can't have some thing writing documents for you because, number one, you're not going to understand it. You're not going to know if it's accurate. You got to know the principles, not just that it looks cool. They wrote this and they put some case law there and it looks. No, you got to understand the arguments of what's underlying that. Until That's you right. can do that, I look at this AI stuff and I bang my head. I got a message today about that. What about this? I said, I don't go anywhere near that crap. Stay away from it. You don't write documents on AI, okay? That's not what that's for. And then sign it, attesting to, under penalties and perjury, that you wrote it. No, nothing about it. So, Aaron Blood, I saw your previous post. So the first thing I would say is, 1, did you record the event? 2, is it within the statute of limitations? And what evidence do you have that it happened? Okay, so each state has a statute of limitations for these things. If you still willingly went in, you don't have a leg to stand on. Because I'm going to tell you, every place that ever asked me to wear a mask, I started recording, and I would not. Right. Yeah, we showed up to a hearing at a Delaware County courthouse, and can't come in here without a mask. I said, I'm not wearing no mask. So I walked through the metal detector, past there. Guy runs up to me with a box of masks. Here you go. I'm not wearing no mask, I said, he said, well, listen, you can't go into court. I said, you going to tell me I can't come into an open public court because I won't wear a mask? Dude, the head guy goes, I'm not dealing with that guy. I'm not dealing with that guy. So they let me and Carmen go. We went. They're not going to let us in the court. So we went back to the court. We walked in the court. Everybody's in there with a mask, okay, except me and Carmen. It's like 30 people, me and Carmen without a mask. The judge and the assistant come in. Guess what they weren't wearing? They didn't have any masks on. So we're only 4 in the court. And guess what? When the judge and the assistant walked in with no mask, don't you think maybe 1 or 2 people in the gallery would have taken their mask off and said, oh, if they're not going to wear a mask, right. They all kept their masks on like good little slaves, whatever, and, just went along with the program, But no, they didn't stop us from coming. Like he said, when you call them on it, they're not going to stop you from coming into a court or going somewhere. And if they do, they got a lawsuit.
Yeah, the only ones that did, I'm suing. All right, let's wrap this thing up. Nobody has anything else. Alphonse, tell everybody where to get in touch with you at, buddy.
Yeah, he's getting on our Telegram group. So you got Big Cities. He's got his 2 groups, and I got my group. And I'm actually thinking about doing another group, Brandon. I'm going to do. I'm going to take the training they give attorneys and break it down. It's a program that they actually attorneys take this course to pass the bar exam.
Yeah.
The information's phenomenal. Okay, there's lectures on there. I'm going to break it down into documents, put it on a group, so that people can understand what fee simple absolute title means.
Yeah, I listened to the Kaplan audio the other day that you posted. Awesome. Yeah, awesome. Very good. Very good. Hey, look, and guys, listen, while we're on this subject, continual education. Okay, for instance, the previous 2 weeks before I wrote the motions this week, I had been so swamped at work and other things that I kind of lost my vision or my idea with law. Sat home for 2 days, reading cases, reading my old motions, refreshed my memory on things. Listen, so when you study something one time, it's in the recesses of your subconscious, right? All you have to do to pull it back out to the forefront of your conscious mind is study it again. And this is called continual education. Always go back through your old documents. Every motion that you write, every complaint that you write, go back through and read it every now and then, right? Especially in my case. I don't have one case. I got 5. So guess what happens when I start writing? We got 30 motions going out. Well, everything kind of starts blending together, especially on my end. But nonetheless, even if you got one case, go back and read your case. Go back and read the case law that you cited. Continually search for other case laws that bolster your position. One of the things that Gary and I are going to try to do is get an A to Z compendium of all the case laws that we've all shared. I really want to do that. And if anybody out there is technologically smart enough and wants to help with this project, please contact me or Gary or Alphonse. What we have is case law after case law after case law in these groups. Okay. Well, the groups have been going on so long now, it's almost impossible to find individual ones. But what I would like to do is get a compendium, say Title 42, 1983, unreasonable search and seizure, put that in the folder. You know, something like we've done with our groups over there in the Big Sib, where we separated the groups, and that's working out really well in each group too. But nonetheless, we'd like to compile all the stuff that we shared because, dude, you get 4 or 5 months ago, for instance, the Newark State versus the insurance company, right? Great quote in there. I can't bring it up from memory right now. But I had to go look it up the other day, and we've talked about that case ad nauseum. So that goes back to
Bridgefield versus Fisher. How powerful was that? Okay.
Yeah.
And listen, we were talking today before we had this thing. We talked about HOAs. You just did an HOA for somebody. I just did an HOA for somebody. And Brandon had no reason to be messing with HOAs, and I had no reason to be messing with HOAs. But we were helping people, and we went and read the declaration of the HOA, and we read the law, and I had from the Kaplan seminar, the property thing, and they go into detail what fee simple absolute means and title, you know, and there can only be one fee simple interest in the property, you know, and then he started talking about granting a buyer clear title, clear uninhibited title, and you can never have clear uninhibited title with covenants in place. Okay, so there can't be covenants in place on your property, which is an HOA. It can't be. And here's really what's going on with that stuff, with the HOA stuff, is, listen, it's the HOA owns the common property. Okay, they control the common property, and they control the undeveloped property. Because an HOA is an ongoing event, you know, if you didn't know that. Actually, when they create an HOA, they have so much property to develop, and they subdivide land. But when they sell the lot to the builder, and he builds it, and they sell it to somebody, they give him a fee simple title, interest. That's a fee simple absolute title, okay? And that's where it says, you know, to the grantee and their heirs and their assigns. Okay. Well, if you understand what fee simple means, it's the highest title you could acquire. Okay. Highest property title you can acquire is fee simple. So how can you have fee simple title when the HOA is telling you you can't park your RV in your driveway? Okay. That doesn't run. That doesn't work. And when you throw this stuff back in their face with the actual law and court sightings, these people have a way of going away. And that's what we enjoy doing. It's why we help these people. Hey, send them this. You know, let's see what kind of response we get. And a lot of times they fold their hand because they know we're going. Like, how many? What'd you say? You had like 5 HOAs went away in your area or something?
Yeah, all these big HOAs up and down Highway 16 are no longer operational, and they're huge communities. But I think when you get one individual or maybe two within that HOA that starts pushing back after the bull crap, that they really have no legal teeth. So let me address this from Enriquez. Look, guys, since I went on the COVID-19 march 3 years ago, at that point in time, this channel was averaging 25 to 30,000 views per video. Okay. Since that time on, I am not being pushed out there by the algorithms on YouTube.
Right.
And I don't even know if people get notices of us going live anymore. If you feel led, you can push the channel, because I just don't have time to go do it. I would love to see the pre-COVID levels come back, but I don't think that the powers that be really want to hear what this channel has to offer to people. So
it's pretty well known that I've known people that had like so many views, and all of a sudden their numbers would change on the views. Like there's something going on. They're doctoring numbers.
Oh, they are. This channel has been blackballed since I went through Walmart, Rouse's, and everything else, showing people that they didn't have to wear the mask. All they had to do was call the corporate lawyer at Walmart the next day the mask mandate was gone. So that was it.
Yeah, it's not, I could care less how many subscribers. I don't care how many subscribers. Yeah. I don't care if there's 10 people in my group or there's 10,000.
Well, that's right. That's right. I'd like to hey, look, it's going to, here comes a synchronicity thing. It's going to find the person that needs it, because this information is tough to digest. It's not easy. It breaks the cognitive dissonance barriers that most people have, like the Saturn cult. You know, that guy, that lady, or that guy's got to break that cognitive barrier. There's a couple more in here that's still stuck on the outside loopy stuff. We got to get back to facts and evidence, okay?
Brandon, how many emails have you gotten from people said you changed how I think about like I could never see this before. Now I understand what's going on. To me, that's wonderful. That's the greatest gift you can give somebody, just to open their view of what's going on.
Just never underestimate the difficulty in changing false beliefs by facts, folks. But the opposite is also true. We never stop using facts and evidence to support our positions.
That's why we're a problem. What they say, the truth's a stubborn thing, right? And when you stick on the truth, you're hard to defeat, man. You're hard.
Yeah.
And that's what we got to do.
Folks, we love you. We'll see you on the next side. Alphonse, thank you so much for coming on such short notice. I really do appreciate it, guys. Give this thing a thumbs up, share it, and we'll see you on the flip side, folks.